The government has published new proposals in relation to flexible working, but what do they mean for employers? Hello, I'm Dominic Walker. Welcome to JMW's Inside Man YouTube channel. Please subscribe to the channel, like this video, and keep the conversation going in the comments section as well. My guest is Chris Deeley. Chris is a solicitor within JMW's Employment Law Department. So, Chris, I guess before we talk about these new proposals, what is the law around flexible working currently?
Hi, Dominic. Yes, so at the moment, all employees, once they reach 6 months service at 26 weeks, have the right to make a formal flexible working request to their employer. Effectively, that means that you can ask to, change the hours you work or the days in which you work, or even to work from home, which is something that I think we've all got more experience of than we expected we might have a few years ago. As I say, that's a right that you get after 6 months service with your employer. And there are certain obligations that come with that at the moment, one of which is to provide some thoughts to your employer about how they can deal with that and ameliorate the effect of you changing your working pattern or the location that you work from. So that's where the law stands at the moment. It is worth pointing out as well that it is only a right to request flexible working. It's not a right to have it granted necessarily.
And so the government has made these proposals. What will change?
So yes, the title of the consultation the government's responded to is called "Making Flexible Working the Default," which I think gives away a little bit of what they're thinking about with these changes. The general tenor of the changes is there's a shift in favour of employees. So the first change to mention, which is the sort of the headline one, is that they are bringing in a right to request flexible working from day one of you starting a new job. There's no longer this 6-month waiting period that you have to achieve in order to make this request. There are a number of other shifts to do with the sort of the process of making a flexible working request. So firstly, you can make now 2 requests in a 12-month period, whereas previously it was only 1. And the deadline for your employer to respond to it has come down as well from 3 months to 2. Importantly as well, there's been a shift more towards a sort of conversation between employers and employees about the flexible working request that's being made and the new arrangements that the company is going to put in place. So employers now have to consult with an employee before rejecting a request. So if they're minded not to go with something that's been requested, they have to sit down with the employee and explore different options that might work for them to try and come to some sort of compromise. Now that might be, for example, you as an employee, you want to work 3 long days a week, but your employer says, no, you can't work 3 days a week, but how about 4? Whereas previously, if they had the good reason, they would have been entitled to dismiss that 3-day request out of hand and without even considering 4 days. The other change is that burden on the employee to suggest how the employer might deal with the changes and sort of minimise the effect. That burden is now gone, so the employee doesn't have to turn up with ample evidence of how things are likely to change, which, to be honest, makes sense because it's information the employer is much more likely to have in any event.
And these things are never easy for employers. How can you and the employment team help employers navigate this?
Yeah, they're definitely not easy to navigate. I think practically the changes will take some time to be felt. And I think that things on the ground may not change too dramatically too quickly. In particular, the reasons that the employer can give for rejecting a flexible working request aren't changing. There are 8 specified reasons in statute, which we could do a whole other talk on themselves, but so there probably won't be that dramatic a change, particularly for industries where people couldn't realistically work flexibly anyway. Having said that, that doesn't stop people from bringing these requests. And so employers do need to be in a position to deal with them. The best way to start that is to have a solid flexible working policy in place, which is absolutely something that we can help draft. If a request goes through, whether it's in the requested form or a modified form, And that then also constitutes a change to the employee's terms of employment. It will change their employment contract. So ideally, you should be updating your contract so that that change is reflected. And of course, there is this whole process, as I've detailed, which you have to go through in terms of addressing a request. And so it's quite possible that employers will have questions come out of that. And we're quite happy to provide ad hoc advice on any day-to-day questions that come out of that as well. We're always on the phone.
Chris, thank you so much for your insight. And if you'd like to speak to Chris and our employment law department, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel for the latest legal news, hints and tips. I'm Dominic Walker, JMW's Inside Man.